So I'm just going to start, and we're going to talk for a little bit, and I want to open it up to questions quite quickly, because I can see there are a lot of people out there who should and will be judges someday, and I want you guys to ask your questions as well. But why don't I start with you, Judge McKee, since you've been on the federal bench for a little bit longer. Why don't you talk a little bit about what led you to want to be a federal judge to start with?
In my days as a assistant U.S. attorney, I was so impressed by the quality of the judicial proceedings, and also really struck with the authority that the judge has to achieve something that I would perceive as just, and that's a very subjective statement. But it seemed to me that if I were going to be in a position to do what I thought I wanted to do with my career, and that is to try to work toward improving the quality of life for people generally, that one way to do that is to make sure that the law is enforced in a way that I believe is fair and just. And I thought the best way to do that would be as a federal judge. At the time, I didn't think it was possible, so I really want to encourage people here, don't get discouraged if you're thinking about it. But it turned out that it was in the cards.
Well, Judge Diaz, you have a similar history of public service. What sort of led you to yourself? Did you have the same kind of feeling that being a federal judge was the best way to serve the Americans in your community, or was there some other precipitating event?
Very similar to Judge McKee. To be perfectly honest, I didn't even know I wanted to be a lawyer. That's my third choice of careers. I really wanted to be a Major League Baseball player. But I quickly found out I couldn't hit a curveball, so that went out the window. I thought about becoming a pilot. I got these extra set of eyes, and that didn't work out too well. And when I became a lawyer, some of the very best mentors that I had in the military were judges, folks who really showed me the way in terms of what it meant to do justice before the bar of the court. And I looked at them and I realized that that was something that at some point I wanted to take on. I wasn't quite sure how I was going to get there, but I knew I wanted to get it done. And actually my career as a judge began in the military when I began practicing military justice, and then was appointed to be a military judge in the reserves, and it sort of went from there.
And well, that's a very interesting background. It's obviously a very esteemed group in the military justice system. And what made you think about moving into the federal system and out of the military system?
Well, initially I obviously didn't progress immediately into the federal system. In 1995, I was at a crossroads in my military career. I've been in the military for about 12 and a half years. And if I was going to continue to serve, I'm sorry we don't have a mic, but I'll project. I wanted to continue to serve, but I also wanted to branch out and try other things in the practice of law. And so I found a happy medium. I stayed in the military reserves and continued to serve my country in that way, but ended up taking a job in private practice down in North Carolina with a large firm. And it was at that point that I began thinking about perhaps becoming a judge at the state court level, and sort of progressed that way. And sort of that's become a much more conventional path, I think, for federal judges on the federal bench to take. I think Judge McKee was a judge in the state court system in Pennsylvania. I was a judge in the state court system in North Carolina. And so I would commend that to you as sort of a starting point if you're interested in becoming a judge, to sort of reach out and focus and begin perhaps your career on the state court bench. Now there are some negatives, not the least of which is the fact that in a good number of the jurisdictions across our country, most judges in the state court system are elected and have to run for office. I had to do that one time. I lost that election. I think running for office as a judge is akin to undergoing a colonoscopy
every day.
But I think that would be doing a disservice to a colonoscopy. It's even worse than that. But that, unfortunately, is part of the price that you have to pay if you want to serve on a state judicial bench. But I would commend that to you as a sort of an entry point into service as a judge. I enjoyed my time as a trial judge in the state court system, and I think it really held me in good stead when I decided to focus on moving across the way, so to speak, to the federal bench.
Judge McKee, since you were also on the state court bench, is that the most significant or most useful experience that you had before being nominated and confirmed to the federal bench? Or are there other things in your background that you think really equipped you for the job?
For me, excuse me, for me it was the most useful and important, primarily because of the point by President Clinton, as you heard. The Clinton administration's approach to making judicial appointments, I mean, it worked out for me because I was told by the person who was then counsel to the president that President Clinton coming into office understood the absence of diversity that had been there in the prior administrations. I believe, I don't want to get this wrong, but I think in the preceding 12 years, and you probably know this better than me, only 3 black appellate judges had been appointed. And that includes counting Clarence Thomas twice, once to the circuit and once to the Supreme Court. So there was a real need to do something about diversity that the Clinton administration realized. And they also realized that one pool that was already there was the state courts. And by going into the state courts, they, I think, realized that it was a ready pool of a much more diverse pool of seasoned jurists that they could then look to assess qualifications for federal appointments. So it was crucial for me. I would agree with Al in terms of the jurisdictions that elect judges. In fact, when we were saying that, not only did I agree with your ranking of the two in the miserable index, but the only thing I could help think of was when I had my colonoscopy, what I remember the most was whatever drugs they give you are wonderful. The deepest, most relaxing and full sleep I've ever had. So I'd say it's a no-brainer. That's much better than running as a judge. And in Philadelphia politics are, I hope they're sui generis. They are breed unto themselves. I learned so much about the political process and Frank Skeffington in ward politics running as a judge in Philadelphia. So I wouldn't necessarily recommend it, but if you have a real yearning and a value for it, and don't by any chance give up your ethics or your integrity, because that's difficult to do sometimes. But you've got to maintain your integrity during the process, no matter whether it's elected or appointed. And you can do that. You can maintain your integrity and still get through an elected judicial process. It's not easy to do, but not only can you do it, but you really have to do it. Because the big test, not only in the state court, but the federal court, and I call it the morning after test. When I look at myself in the morning, what am I going to think about the guy looking back at me? And as long as I can pass that test, I'm okay. And you kind of, I think, have to remember that, not just in running for the judgeships, but as a practicing attorney. It's an important threshold to bear in mind. If you conduct yourself in that way, you can get through the judicial process in the electoral context and still come out the other side in a kind of a whole person and someone who still has some manner of self-pride and ethics left.
Well, some very interesting remarks about the similarities and differences between colonoscopies and running for state judicial office. But I'm wondering about the federal branch. Is there an equivalent medical procedure? Is it the same one, or how would you characterize your experience? And both of you have had, you were different administrations, different time, different process, a little perhaps more heightened difficulties in moving through the Senate. And I wonder if you both would sort of jump in and comment a little bit about what that experience is like, and any suggestions you might have for our audience about things to prepare for if you're going to be nominated and you're going to go forward.
Well, I would say get ready for a long wait. The reality of the process now is that a nominee, no matter how well qualified, no matter how uncontroversial, is going to get, unfortunately, more often than not, is going to be caught up in larger political issues that oftentimes have nothing at all to do with the candidate or his or her merits or lack thereof. That's the reality of the process. It's intended to be an apolitical job. It's a very political process to get there. And if you haven't figured it out, I'm not a politician. There's not much about politics that I like, but the reality is that you have to be involved in that process while maintaining your integrity, as Judge McKee mentioned. And realize that the decision makers, the folks who are going to make the call as to whether or not you're nominated in the first instance and confirmed, are folks deeply embedded in politics, and you have to be able to get along with that process and understand it. In my case, I didn't know any of the decision makers at the Senate level, my home state senators, very well. Senator Kay Hagan I'd met a couple of times. Senator Burr, Richard Burr, the Republican senator from North Carolina, I had never met. But I did know a lot of people who knew them and who knew of me and my reputation as a judge and as a practicing lawyer. So I think the first piece of advice that I would give to you all is, particularly the young folks who are beginning their legal career, is you build your reputation as a lawyer from day one. And it's your reputation as a professional, as a competent lawyer, a lawyer of integrity, a lawyer of commitment to justice. All of those things that you build upon each and every day are going to be important, because when the day comes for an administration to be looking for lawyers to nominate to the bench, if you're not at the top of your profession in your legal community, it's going to be difficult for you to get to a position where that conversation can be started. And so that's the first thing that you need to do. And of course, I have little doubt that most, if not all, of the people in this room are there or can get there. And the question is, what do you do after that? Once you're in the conversation, how do you distinguish yourself? And that's where making the connections to the affinity bars that are represented here today, to the local and state bar associations in your home states, to the local politicians and bar leaders who can advocate on your behalf, that's where that becomes so critical.
Judge McKee?
Yeah, I totally agree with that. I did not know either of my senators at all. We had, at the time I was going through the process, there was one Democratic senator, one Republican senator, but I did have a very good friend who was influential in Democratic politics on the state level and even nationally to some extent. He knew the Democratic senator very well. And he just called him up one day and said, look, do me a favor, will you interview this guy? And he's interested in a federal judgeship. I'd always thought in terms of district court. I'd never dreamed circuit court. I'd always thought district court. I'd tried for many years. In Pennsylvania, had 2 Republican senators, and was told by the chief of staff of one of my home state senators that the president had told them, the Senate, the senator's office, like no Democrats need apply. And the senator was good government minded. His response was, look, we've got to diversify. We can't be that partisan. We've got to open this up and make it more of a bipartisan, nonpartisan process. The response that came back from the White House, allegedly, was, we'll make it more of a bipartisan process when they control the White House. But as long as we control the White House, no Democrats need to apply. So I kept bumping my head into that stone wall of 2 Republican home state senators. And then by fluke, really, we ended up for a brief period of time with a Democratic senator whom my friend knew and called and said, look, will you interview him? And I really thought I was going for an interview for a district court. I mean, it was supposed to be a 45-minute interview. And we must have talked for 3 hours. I mean, I fell in love with it. It was Senator Wofford, whom I still have so much regard for. And I read his book the weekend before the interview. And I thought, I mean, this is a kindred spirit. He believes in all the things that I believe in. He's somebody I can respect. And boy, we really hit it off. As I said, we're going for 3 hours. And so out of that, he became a real proponent of mine, which I had not dreamed of before. And in the conversations, the circuit court got introduced. Actually, one of my now colleagues suggested to me that I try for the circuit because he said the politics were easier. And he actually suggested that when we had 2 Republican senators, knowing I was a lifelong Democrat and very active in a lot of community organizations which would very readily brand me as a Democrat. He said, look, it's just easier for you politically because it's removed from the senator's hands. The senators still have a say in it, but it's not a direct senatorial line the way the district court is. And I think the pamphlet that I looked at does a very good job in laying that out, the difference in the process for the district court and the appellate court. So that was what got me thinking about it. But after my meeting with Senator Wofford, the discussions kind of unfolded in that vein. And they kind of progressed in a way that I wouldn't have dreamed they would have progressed even a year earlier.
So, not an appendectomy even then?
Well, you know, the difference is when you have the colonoscopy, you know who's working on it. You know? And when you run for election on the local level, you know who's working on you. For the federal election, it's like blind. You don't know who's working on you. You don't know who the players are. You know who the 2 big players are, the home state senators. But beyond that, as Al said, it's not necessarily personal. It's that famous line from The Godfather when they're putting Tezu in the car to liquidate him. When it turns to Tom Hayden and says, tell Mike it was only business. I always liked the kid. You know, and Tom goes back and says, Mikey understands that. He knows what's his business. And that's what it is. It's not about you necessarily. It may be about you. But it's really about people posturing a lot and playing to home crowds and trying to make ideological points. And you get caught up in that process. So, and you don't know who the people that they're trying to make points to necessarily are. At least in my mind, it's kind of a nebulous constituency that they're applying to. In that sense, it's harder than running for state court. And in a different way, more political. It's a very different kind of politics, but I think probably more political because the politics are much different, much less local level, and it's much harder to operate. At least for me, it was much harder to operate in that sphere.
I don't want to occupy all the time and be selfish, and I'm sure all of you have great questions. But I do want to ask one final question before we open it up. And both of you have been on the state courts, have now been on the federal, on the circuit court. Talk a little bit about what you see as the value of diversity, and how has your experience perhaps differed from majority judges? What are the, obviously Presidents Clinton and Obama put a lot of effort into ensuring that the bench grew somewhat more diverse, although not as much as you might like to see. And it'd be terrific to talk a little bit about sort of how that adds to the legal community and the process.
Sure. I kind of regret bringing up the conversation about surgical procedures.
I'm going to make sure this hounds you. We get together every 2 years. Every circuit judge in the country is going to know.
I have a confession to make. I've not yet had a colonoscopy. But it's coming. But thank you for that. I think Bert summed it up very well when he talked about the value of diversity on a global scale. The legitimacy of our institutions as a whole, not just the judiciary, but every branch of government, is affected positively or negatively by the diversity or lack thereof in the folks who make those decisions. And certainly on the bench, the fact that a citizen can walk into a courtroom on the Fourth Circuit or in North Carolina or in Philadelphia and see somebody that looks like him or her, while perhaps obviously not necessarily affecting the substantive decision-making on a daily basis, makes a difference in the perception of how justice is being administered in that court. So in that sense, it's critically important. I also think as a matter of substance, inevitably, by virtue of our varied backgrounds, and this is particularly important on the appellate court, where you alone, your opinion by itself, doesn't matter one bit if you can't convince somebody else of the correctness of your position. Having all those different viewpoints in the room, being able to talk to folks about different experiences that you have by virtue of your background, both personal and professional, I think is vitally important. And then the third thing that I would say is that in terms of the future of our nation, the ability to have folks in positions of power and authority that young people can look to as mentors and for future aspirations and hopes of being able to aspire to great things. You can't put a price on that, but it's obviously substantial. And I think all of those things are reasons why diversity is critically important on the bench and across all of our institutions in our society.
Yeah, I couldn't agree more on all three things. One, the mentoring aspect, which I hadn't really thought that much of until Al brought that up. It's important. But the legitimacy of the court is so crucial. We don't have any currency of coercion other than the respect that the people have for our decisions. Many years ago, I was giving an address in Moscow to a group called the Council of the Russian Judiciary, which is an elected group of judges from across Russia, about 200 people in a room, kind of like this. The view wasn't quite as nice. It was a hell of a lot colder. It was October and there was a blizzard outside. And I gave them the example of Watergate, and they were familiar with that, but I explained to them that during Watergate, President Nixon, who was a Republican president, obviously, had in his possession evidence that he knew if he released it to the special prosecutor, it would end his presidency. And yet a court, unanimously, Supreme Court, ordered him to turn it over. And he turned over the tapes without hesitation. And after I discussed that, one of the judges, I'm not sure where he was from, came up to me and he said, and this is all for an interpreter, but he said, I thought I understand your country better than I apparently do. He said, it's my understanding that the president of your country is in charge of the armed forces. And I said, well, that's right. He controls the Army, the Navy, the Marines, the Air Force. He can call the National Guard if he has to. And the judge's response to me was, well, how many battalions does the Supreme Court control? And I said, none. And he said he could not understand why he would turn it over. And I said, you really had no choice. The culture in the country is such that he really had no choice, really because of public opinion. And then his response was, well, I don't understand why the president can't control public opinion because he has access to the arms of the media. It was just a different cultural disconnect. So the fact that we are seen as being legitimate is absolutely crucial. And if to the extent we be seen as being a bastion of old boy elitism, we undermine our legitimacy and we thereby undermine the foundation of the republic. But the other point Al made is also crucial, that our backgrounds really do matter. I had a couple instances with a colleague of mine I developed a great deal of respect for. I won't say he was the most conservative judge in the court, but damn close to it. Not Sam Alito, so not talking about before he goes. He said, I'm not talking about Sam. And there were a couple of cases where we exchanged memos, and I was able to convince him. There were a couple where he was able to convince me. But the richness of the dialogue, in fact, when he resigned, left the court, we talked about that. Every time we get together now, we talk about that. I really miss him testing my view, and I hope he misses me testing his views. One very real example, an immigration case, was the situation where someone who I think was from Liberia testified before the Bureau of Immigration Appeals, and we get an awful lot of immigration appeals, that he was beaten up and would be persecuted if he went back to his village because his father was the leading opposition to the person who was now in control in that area of Liberia, and the person who was in control had some political clout nationally, so he couldn't successfully relocate, which is one of the things you have to show to get asylum. But there was really no corroboration. It was really just the alien's testimony before the immigration judge. The immigration judge found him not credible because his testimony wasn't corroborated. He said that he was beaten pretty severely, did not seek medical treatment. There were no hospital records, and there were no witness statements to corroborate that. The panel, and I knew this, I was not on the panel, but we have a tradition, which a couple of circuits, not most of them have, that whenever we publish a presidential opinion, it circulates to the entire court so that all judges have to sign off on it, and we all have an equal opportunity to weigh in and make suggestions after it clears the panel. I read this, and I sent a note to him, and he was the offering judge. I said, I don't understand why you're insisting on corroboration. What kind of corroboration would you like? And he wrote me back a note saying, well, there are no medical records. And I said, and I had just done a couple summers teaching in Ghana, in the capital of Ghana, which was much more industrialized than this area of Liberia where this person said he was from. And I said to him, have you ever been in a village in Western Africa? What kind of hospital records would you expect him to be able to find? I said, more than that, have you ever tried to get your own hospital records? In this country, try getting your hospital records. It ain't so easy. You get your discharge summary and that's it. But there's nothing to suggest that this guy was anywhere near a place that would be a hospital. And I recounted to him a trip I took from Accra to Kumasi several years ago. It's about a 3-hour drive, and my wife is an internist. And we went by this, you can call it a building, and it's being gracious. It was kind of a corrugated tin and mud hut, and it had a big red cross painted on the side of the building. And out of curiosity, I was just wondering, and I looked for utilities going into the building. I saw none. And there may have been underground utilities there, I don't know, but I doubt it. So chances are there was no electricity in that building, and it had a sign out, it had the word hospital misspelled on top of it. But for that region, that was the hospital. And I couldn't imagine going there to get treatment and getting any kind of hospital records, number one. Plus, in some kind of indigenous societies, you really don't depend on that kind of medicine. You go to someone else in your community who's known as a healer or whatever the local term is, and that's where you go for treatment. And many times you get better treatment than you'll go to get at the hospital. I said, so why are you importing your view of what a person would do in that situation onto this alien? So what he thought about it, he wrote back and he said, well, it's okay, Ted, you have a point. But then he said, one more thing bothers me, and that is there are no witness statements. And I said, in a memo, think about what you're saying. In this society, you can't get people to come forward and say they were witnesses to the police beating up somebody. You can't do it very easily. If what this guy is saying is true, and someone came forward and corroborated his testimony, they were endangering their own lives. So the fact that he had no witness statements, to me, corroborates his testimony. It doesn't undermine it. And he wrote back a note, and he sent a memorandum to the court saying that he was withdrawing the opinion. He was going to rework it. He reworked it, sent it to the panel, this time reversing and remanding back to the BIA. And he ended up, it went back to the BIA. I don't know what happened, but I assume from the way the final draft was written that we remanded it with the kind of language that would tell the BIA that corroboration by itself, corroboration is not necessary. The alien's testimony by itself can make out a claim for asylum, and we have cases, as does every other circuit, saying that that's the law. But had I not had that different world view, that different set of circumstances, that discussion would never have occurred, and that opinion would have been filed as initially drafted.
Thank you. That was it's a very moving story, and I have to say that so for those of you who are thinking about becoming judges, you may not get a battalion, but you will potentially change or even save people's lives. And so I think that's very inspiring, I think, and I hope inspires all of you to think about this process. So I want to open it up because I'm sure there are a lot of questions out there for our esteemed friends from the federal bench. So questions?
You should plant a few.
In the back? Oh, you? Yes? Yeah.
Hi. My name is Lauren Weinstein. I'm the outgoing Vice President of the Harvard Law School Chapter at ACS, so thank you for being here with us today. I'm wondering, you both mentioned mentors. I'm wondering who were your mentors and who helped you get to where you are today? What would your advice be to a young lawyer looking to build her network to one day reach such a position?
I mentioned folks in the military who I work with who were military judges. Now retired Brigadier General Ted Hess was one of my primary mentors at the appellate government division where I worked for many years as an appellate lawyer. There are a number of other military lawyers where I work with and practice with who I would come to for advice. Mentors are folks you can find across a wide spectrum of areas. They're professional mentors, personal mentors. Folks in the Bar Association I think are important to have as mentors and advisors. The key is to find someone that you can trust implicitly and go to for advice when you're not sure exactly about something that you're about to do, whether it be in your daily, in a daily practice of law, whatever the case may be. In terms of judges, those of you who practice in your respective courts on a daily basis, the judges who you appear in front of are folks who you ought to come to and ask for their advice as to how they began their career, both as a lawyer and as a judge. I did that when I came to practice in North Carolina. I spoke to a number of the local judges in my home county about the political process of getting appointed and elected as a Superior Court judge in North Carolina, and they're very, very accommodating, very willing to help. I think most judges want the very best to come into the system, both at the state and federal level, and want to help those who are willing to try to make that effort to make it happen. So I would encourage you to reach across those aisles and talk to judges about their experiences in terms of getting on the bench. I think you'll find that very enlightening and very helpful.
I was thinking of mentors, and three people came to mind. One of them was a lawyer that I worked with at my first firm, who actually I went to the firm because of him. I remember during my interview, it came out that he had just got done revising the state's mental health law, and he also had done a special white paper heading up a task force looking at rape on buses. And this is a long story, I won't get into it, but basically rape on buses that were being used to transport prisoners down for their hearings and trials. The buses were constructed in such a way so they couldn't see what was going on. The DA at the time was concerned about it and appointed my mentor to head that up. And that came up during the interview, and this was maybe 3 or 4 people in a round table along with myself. It wasn't one-on-one. But I left there feeling so convinced that this was a firm I could feel very comfortable in, because initially I wasn't sure about how happy I'd be in a big firm. But they seemed so public-spirited that I thought I could be very happy there. And he turned out to be someone that I stayed in touch with while I was there, afterward in the U.S. Attorney's Office. In fact, I went to the city solicitor's office because my friend was Alan Davis, who some of you may know. He's passed away several years ago. I called Alan. He was appointed city solicitor by the then mayor to congratulate him. And he asked me if I wanted to work for him as a deputy, and I thought, if I don't leave here now, I'll probably never leave because I love this job. And so I went to work with Alan, and I jumped at the chance to work with him some more. Somebody else was somebody from undergraduate school who really taught me the meaning of rigor. And that, I think, was one of the two things that I contributed with my success in law school, was a real academic and mental discipline that I didn't really have before I took a few courses from this undergraduate professor. And the other person, and some of you may be able to identify this, my martial arts instructor, who, again, disciplined at a whole different level. But I think more than, if I had to name one person who was responsible for my academic success, it would be my martial arts instructor, because of the discipline and the ability to do some things to relax and deal with tension that we all should be able to do. But the mentoring is important, and all three of those people, I think, at some level, became mentors. The judges that Al mentioned, I think, would probably be much more open to that kind of relationship than many of you might guess. If you have an entree to the person because you've appeared in his or her court, most judges, I think, would be very happy to see that somebody interested in going on the bench would be very happy to share their experiences with you and kind of take you under his or her arm. But I don't think that's too much to expect at all. Some would not, obviously, but many would.
Yeah, you know, the Senate has all these wonderful traditions, including the blue slips process and the hold process, in which a senator can block a hearing on it and the judge. And I wonder if I could have your thoughts on whether that affects diversity in the federal judiciary, and whether the Senate hold process allows for covert discrimination.
Oh my God, yes. I mean, the Fourth Circuit is a prime example of that. It wasn't until a few years ago, I guess, we got our first black circuit judge on the Fourth Circuit. Now it's probably the most diverse circuit in the country. If not, it's got to be one of the most diverse circuits. But absolutely, it does. And that's one way I think the local politics of running for office kind of gave me a leg up with navigating the whole appointment process. I remember when I decided I was going to run for a state judge, I went to the only politician I knew who was a friend who was then on city council. He was also a ward leader. And he asked me, "Who's your ward leader?" And I said, "I don't know." And he said, "Well, what ward do you live in?" I said, "I don't know." And he was aghast. And he asked me where I lived. I told him my address. And by just the address, he knew who my ward leader was and what ward I lived in. He said, "Go down and see him first. Don't tell him you saw me. Then come back after you've gotten his support, and then I'll help you there." But this conversation we're having never happened. He explained to me, I did not want to put myself in a position where I offended his ego. And if one of his constituents went around him, as he would see it, to get support to run for a judge, he'd make sure I never got on. He, my ward leader, would make sure I never get on the bench. Some of that kind of sensitivity, I think, goes on, and in that sense, it is personal. It's not like Michael Orleo on the federal level. I can't tell how much of it because you really don't know. I do believe very firmly that the friend of my enemy is my enemy, and my enemy's enemy is my friend. And I think a lot of senators probably function on that level. And you don't want to tick people off or run them the wrong way. That's for darn sure, because that can be the end of it.
I think the whole process of holds and delays in the process is a disincentive to people at large to seek judicial office. It remains an honor to be a federal judge, and certainly I was honored to have been nominated. But you know, the fact that most people can expect to endure waits that sometimes exceed in excess of a year is a huge disincentive for people to put themselves through that microscope and that process. And particularly for people in private practice who oftentimes have to put their practices on hold while the process grinds ever so slowly to some interminable. And I don't know how Judge McKee feels about this, but as a state court judge, I was in a slightly better position. You know, I could go on with my life and just wait things out. It didn't make waiting any easier, but it certainly is very different from someone who has a private practice, whether at a small or a large firm, to have to endure the kind of wait and uncertainty that comes along with this process. So it's a huge disincentive, and one that hopefully will change. I'm not overly optimistic that it will anytime soon, but I couldn't agree with you more. It is a tremendous disincentive to anyone seeking a position on the federal bench.
start.
Yeah, Bill Troy, the ABA. Judge McGee, you mentioned the diversity asset, the legitimacy of court. Does the lack of diversity undermine that legitimacy? And I'm not talking about people on the bench, but affiliations. You might be familiar with what's happened with the Sixth Circuit, with the bankruptcy Judge Payne, and the issue of whether he should have been disqualified or as an ethical complaint. But when somebody is affiliated with a club, for instance, that bars blacks and women like the Bellevue Country Club, does that by essence undermine the legitimacy of the court? Can I ask that for both?
I think it does, yeah. If you have someone who belongs to a club that discriminates, I don't know that situation, so I don't mean to comment specifically on that.
I'll send you the New York Times.
Okay. For the record, I'll have read that after I make these comments. I'm not referring to that. And I guess the best way to answer it is my own visceral reaction. That if I know someone has been in a club like that, and then they go on the bench, you have to wonder what their own personal views of fairness are. I mean, I could not believe.
Well, he's still in the club.
Yeah, I couldn't imagine belonging into a club, I couldn't imagine belonging into a club that discriminated against women, against whites. And why would I want to associate with those people? Those are not the kind of, life is very short. None of us have a lot of time during the day. Why would I want to spend my time with them? I just wouldn't want to do it. And if that's the mindset the person is bringing to the bench, I think it would create a real message problem, put it that way, a real message problem. One of my colleagues, it can be done unfairly. One of my colleagues belonged to a gun club. In fact, he was, this is many years ago, like 10, 11 years ago, and he was lobbied against pretty strongly by the progressive bar associations, not necessarily, but the progressive associations, locally and nationally. And he's since become possibly my best friend on the court. In fact, he called me the other day from Turkey, and we're kicking around an opinion. I don't think, we've only agreed on one criminal case the entire time I've been on the court with him, and he tells me with a chance against it he was wrong. I dissented in a case that was clearly to me driving while black. He didn't see it. And he tells me now, I'm going to tell you, you were right. My law clerks told me you were right. I should listen to them, you were right. But again, it goes back to experiences, and it does cut both ways. If you're someone who doesn't have a problem with being in a club that is discriminatory, to me that sends a message to the community about the kind of reception they're going to get in your courtroom. I can be wrong, as I said about my friend. His problem was a gun club. But he is, we've become very, very close. It's not a situation of liberal balance and conservative, because he's much more liberal, I think, than anyone realized he was when he was in the nomination process. I hope that answers your question.
I'm not familiar with that news article either, but I agree with everything Judge McKee said. Nowadays, as part of the Senate questionnaire, you're required to disclose those affiliations. And I can't imagine that anyone would pass muster in this day and age and get very far with those kinds of affiliations, because that's one of the sort of immediate things that come to the fore, and people begin talking about it. In fact, that were the case for a nominee. And I do agree that it sends a clearly inappropriate message to those who would come before that court.
I didn't go differences. I belong to a club organization. I'm now really inactive in it called Concerned Black Men. That everybody who was part of the organization was black. It was mostly retired, almost except for myself. I guess everybody was a retired policeman or firefighter. And they formed many years before I moved to Philly to try to deal with gang violence in Philadelphia as a way of mentoring and gang intervention. And it wasn't discriminatory in its admissions process. It was just, it was open to anybody who wanted to join. It was just that people understood that we're dealing with black gangs, that this is an organization primarily of people, police officers and firefighters, as I said, who are retired, and they're all black, and no one really asked to join. So women's groups may be the same way. If you belong to an all-women's group, and the agenda of the group is trying to advance gender in the workplace and gender fairness generally in society, I don't think that that would be held against you. I probably remember the Little Rascals, but there was an episode of one of the Rascals belonging to the Female Women Haters Club, or the He-Man Women Haters Club. I'm not talking about that kind of club. So for clubs that form around historical disenfranchisement, I think it's different. But even if they have a formal policy of segregation or discrimination, I still think it's a real problem, and it's a thing you should avoid.
Well, I think if we may have time for one more question. Is there any in the audience? Yes?
Did anything in your paper trail, law review articles or lower court decisions cause any hiccups in your confirmation process?
That's a good question. I mentioned this earlier. On paper, I looked incredibly conservative. I was a federal prosecutor for years in charge. When I was with the city solicitor's office, I was primarily in charge of code and tax enforcement in the city of Philadelphia. And the parking authority is kind of a nightmare that I suffered through for 9 months for political reasons that I can get into after we break up. But even that was enforcing ordinances, enforcing regulations. I had a couple of cases when I was a state court judge that had me kind of looked deeply into them. Could have created some problems, death penalty opinions, could have created some problems. My procedure, unlike y'all's, was very fast. It didn't seem like it was fast at the time when I was living through it. But I got a call from someone very much involved in the process who told me, look, just don't take any controversial cases. Don't take any cases dealing with abortion or the death penalty, and we'll get you confirmed in 60 days. And I got that call before my hearing. As I was saying earlier, it was between 58 or 62 days that I was confirmed. It was just, he just ran it right through. But that was a very different time.
I guess I'll answer that question by making a general comment, is be prepared to be criticized. The process has become such that no matter what you believe to be the merits of your experience and the work that you've done, someone is going to be able to pick and choose and pick at something to criticize you about in your career. In my case, it was primarily my work as a lawyer in private practice. For some reason, I was identified as the tobacco litigation lawyer for Philip Morris when I was a mid-level associate in a warehouse looking through documents in a couple of isolated cases. But all of a sudden, I was Philip Morris's general counsel, heir to a throne and the strategist, the sort of the person pulling the strings behind the curtain. And there were other cases like that as a lawyer and as a judge where I had made a decision or advocated for a particular point of view as a lawyer, and those, some folks anyway, were a little bit critical about. But by and large, it wasn't a big deal. But the point that I would make is you need to be prepared to respond to those issues because they're going to come up. If you have a paper trail, for example, as an academic or otherwise, that seems to be the kiss of death these days in terms of your ability to be nominated and confirmed as we've seen recently. That's not to suggest that you ought to shy away from being a scholar or writing or speaking regularly. But when the time comes to be considered for a position on the bench, recognize that those issues are going to come up, and you're going to have to be able to deal with them intelligently and make sure that you have a ready response for the criticism that's bound to come.
I mean, that's absolutely right. In the meantime, we're all going to be vulnerable if there's a paper trail, but you can't live your life avoiding the paper trail in the hope that one day you'll become a federal judge. Trying to figure out whether or not that's going to happen is trying to predict where lightning will strike on the 23rd of July. You can't do it. So you kind of have to live your life in a way that you're happy with, that you're content with, that you're satisfied with, that brings you the kind of professional and personal rewards that you'd like to get from your profession and from life. And in the meantime, with certain opportunities come your way, so you can maximize the chances of moving toward a judgeship, either on the federal level, or the state level, or the administrative level. By all means, take advantage of them, but I would really caution against pigeonholing yourself to the extent that you become cloistered away. Don't do anything which is professionally or personally gratifying in the hope that nobody will find anything to criticize you for. Somebody will find something to criticize you for, whether you work assiduously to avoid it or not. So just live your life. But in the meantime, also, as Al said, really strive toward excellence in becoming somebody in the legal community who's recognized for their ethics, for their intellect, and for their excellence. Because that is really what kind of gets you on people's radar screen when you go letting folks know that you're interested in a federal judgeship.
Well, I want to thank our esteemed judges for participating in this discussion. I want to thank the partners who helped put this wonderful brochure together. It does say in here, not explicitly, but more or less, that don't join the He-Men's Women Haters Club. That won't help you. It has lots of other good information, but I think we've heard real words of wisdom from Judge McKee and Judge Diaz, and so I hope you will join me in giving them a round of applause.